Hello everyone, welcome to CashcroftTV. My name is Kalen Ashcroft. Thanks for watching another video, or your first video, on Guide to Legal History and Historians. Today we will be covering Daniel Klerman and John V. Orth's respective chapters in the Oxford Handbook of Legal History, which I actually do not have with me today. It's at my office. However, in my other videos you can see what it actually looks like. It has a nice owl, which I think is symbolic of wisdom. Also happens to be the pet of Harry Potter, so I think there's a lot of wisdom in that itself. So, nonetheless, we will begin with the two chapters by these two respective legal historians. And my apologies if I go a little quick through this one. I already have 22 pages of typed notes, so it's going to be long if I do not do it in this way. So a little bit about Daniel Klerman, a little biography before we go into his chapter. So he is the Edward G. Lewis Chair in Law and History and the Edward G. Lewis Professor of Law and History. He's also the director of the Center of Law and Social Science, which is abbreviated as CLASS. And this is at the U.S. University of Southern California Gould School of Law. He teaches civil procedure, property, concepts in American law, and English legal history. In 2014, he received the Student Bar Association Faculty Appreciation Award for Outstanding Professor Award. He was previously an assistant professor at the University of Chicago School of Law from 1995 to 1998, an associate professor later at University of Southern California in 1998, and through which he stayed until he is now then became a professor in 2001. He had been a law clerk for Justice Stevens at the United States Supreme Court, as well as a law clerk for Judge Posner at the Seventh Circuit Court of Appeals, United States. He graduated from the University of Chicago with a PhD in history in 1998, as well as from the University of Chicago with his Juris Doctor, where he was Order of Coif, and on Law Review, graduating in 1999. And his undergraduate was at Yale College, where he received his Bachelor of Arts, summa cum laude, and Phi Beta Kappa in 1988, and majored in history, mathematics, and philosophy. He's also been a Fulbright Fellow in London, as well as an Olin Fellow through the University of Southern California, also through the Taiwan Ministry of Science and Technology grant for $93,000 with Yun Chang for his Theoretical, Empirical, and Policy Analysis of Settlement article. In 2004, he received the Sutherland Prize from the American Society for Best Article on English Legal History. He was also the chair of the American Society from 2014 to 2015, or the American Society of Legal History, pardon me. His publications include Forum Selling, published in the Southern California Law Review in 2016 with Greg Riley, as well as Inferences from Litigated Cases, published in the Journal of Legal Studies in 2014 with Yoon Ho Alex Lee, as well as Jurisprudence, Competition, and the Evolution of the Common Law, published by the University of Chicago Law Review in 2007. And he also has countless more articles as well, some of which are listed on the PowerPoint slide, which we will cover shortly. His scholarship is primarily concentrated on civil procedure, English legal history, and law and economics. So his chapter in the Oxford Handbook of Legal History, edited by Marcus D. Dolber and Christopher Tomlins, is titled Quantitative Legal History, and it is in part 2 of the textbook, Approaches Conceptualizing Legal History. This particular video will be a little different from the others because we'll be crossing from section 2 into section 3, so these individuals might be less comparable than others, but we shall see in the comparison shortly. So, in terms of the introduction, firstly, the author thanks Scott Altman, Sam Ehrman, Bob Gordon, Aurelia Gross, Philip Hoffman, Naomi Lemereau, Paul Mahoney, Chris Tomlins, one of the editors of the Oxford Handbook of Legal History, and Gavin Wright for their helpful comments and suggestions. So, starting with the introduction, so quantitative legal history, he says, is in a rather sorry state. Only about a quarter of the recent works of legal history use even simple quantitative methods, such as tables or graphs, and articles or books with more sophisticated methods, such as regression analysis, are extremely rare. This limited use reflects in part the marginal place of numbers in scholarship produced by historians. On the other hand, the increasing prominence of empirical work in law more generally, and given the emergence of new techniques in the quantitative analysis of texts, the infrequent use of statistical methods is surprising. So despite these trends that might indicate that this should be increasing, it's still relatively a slim proportion of legal history documents include quantitative methods. And he believes, and this is likely true, a missed opportunity. Other fields, including economics, sociology, and political science, are using statistics to analyze legal history outside of the legal historian actual field. It's particularly helpful in understanding the effect of legal change and in analyzing the influence of multiple factors on legislation, judicial decision-making, and citizen behavior. He thinks it's wonderful that people from other disciplines are using statistics to analyze legal history. However, legal historians themselves might be able to do this better, given their penchant for archival work and their superior knowledge of historical sources, context, and theory. So although it seems as though the other disciplines are in some ways covering this for the legal historians, he thinks the legal historians themselves have an obligation to do this themselves. He says legal historians can learn basic statistical analysis in graduate school or on their own, or they could collaborate with statisticians or social scientists with quantitative expertise. Surprisingly, this is rare in legal history, however, so there are means for them to educate themselves or collaborate, but it's still quite rare. While co-authorship is relatively common in other social sciences, he observes, collaboration between legal historians and quantitatively sophisticated social scientists presents a terrific opportunity, he says, for interdisciplinary work that could enrich the field as well. So in terms of this chapter, it will first focus on by assessing the quantitatively the use of quantitative methods in legal history. So what better way to measure the use of quantitative legal history than using a quantitative method? And then it will proceed to then it will then discuss a few examples of successful uses of numbers and statistics in recent books addressing legal historical topics. And then it'll finally conclude in section 3 by discussing the future of quantitative legal history. So, part 1, the quantitative analysis of the use of quantitative methods in legal history. So, in this section, it attempts to document numerically the extent to which quantitative methods are in fact used in recent legal works and legal historical works. And he notes this is not a trivial task because the field of legal history is not well defined, and the range of techniques that could be quantified as quantitative is vast, and it's a gray area. What is quantitative and what is not quantitative? What is legal history? What is not legal history? So he creates this table, which is just one approach to doing this, and he examines it under 4 categories: scholarship, articles published in legal history journals in 2016, books reviewed in legal history journals in 2016, and prize-winning articles between 1988 to 2016, and lastly, prize-winning books from 1980 to 2016. But you could still subdivide which journals and which prizes would be an area of further study. So in the articles he examined were those published in mainly English language legal history journals, including the Law and History Review, the American Journal of Legal History, the Journal of Legal History, and the Law and History Journal. The first 2 are published in the US, and the third in England, and the fourth is a journal of Australia and New Zealand. But you can see here that it is predominantly English focused, so the same truths might not be applied in other jurisdictions. The prizes are the Hearst Prize, awarded by the Law Society Association for the best work in socio-legal history, and 5 prizes awarded by the American Society for Legal History. The Surrency Prize, which includes the best article in Law and History Review, the Sutherland Prize, the best article in English legal history, which he had won, and the Cromwell Article Prize, the best article in American legal history published by an early career scholar. and the John Philip Reed Prize, the best monograph on Anglo-American legal history by a mid-career or senior scholar, and the Cromwell Book Prize, the best book in American legal history by a junior scholar. So his findings essentially was that about 14% of articles in 2016 and 26% of books reviewed in 2016 had quantitative tables or graphs. So it's more likely in the books than in the articles. However, books are longer, so there's more reason that there might be included. And he said this could be seen as reasonably wide usage, but the greater use of numbers in books might also reflect the greater length, as I noted. But the second finding is that the prize-winning articles in books use tables or graphs at a higher rate, at 22 and 28% respectively. So for articles, it's an increase of 8% higher rate of winning a prize if it included a quantitative table. And for books, it would be 2% more likely to win a prize for if it included a quantitative tool. However, this is not correlation, does not mean causation, but these are the findings, which indicates that the prize committees are receptive to quantitative work. It is also possible that the difference between prize-winning works and works reviewed or published in 2016 reflects greater use of quantitative methods before 2016 as well. The prize data came from a longer period as well, from 1980 to 2016, so it could just be that there's been an increase in the use of quantitative methods, and there is some evidence that earlier works were more likely to use statistics as well. So, for example, we're comparing the longer range for the prizes, and so it could be evidence that there's actually a decline in the use of quantitative methods. And there's some evidence, yes. And although the number of works analyzed here is insufficient to test the hypothesis rigorously, so there's not a large enough sample size, one particularly noteworthy early prize winner was Lawrence Friedman and Robert Parzival's The Root of Justice, Crime and Punishment in Alameda County, California, from 1870 to 1910, which used 68 quantitative tables. And this was published in 1981. So that adds to the thesis that maybe quantitative tools were more popular previously, but furthermore, if it includes only one quantitative tool, it qualifies as under this category, whereas some, such as this, include 68. So there's also maybe a spectrum within it as well. A much smaller percentage of works contain more sophisticated quantitative analysis, whereas only 4% of articles published in 2016 contain a two-way tables, and the use of two-way tables is lower for prize-winning books and articles as well. So once we start getting into sophisticated quantitative metrics, it's very small numbers. However, there's still, in terms of the more complicated quantitative tools, they are still more likely to win if they included it, but not causation once again. This allows researchers to see that a two-way table allows you to see how two factors affect the same variable, and most of the articles with two-way tables came from a single special issue of the Law and History Review devoted to digital humanities. So even the numbers of complicated quantitative tools came primarily from a special issue. If that issue were excluded, only a single article published in the 4 legal history journals in 2016 had two-way tables. So it's very, very uncommon and skewed by this one issuance. While tables can be used effectively, he says, to analyze the influences of two factors, they become more cumbersome when analyzing 3 or more factors, and therefore need regression analysis. Very fascinating topic, which if you don't understand, you should study it. It's very important. And it's the standard way of exploring multiple factors, such as the Fama-French model is a form of regression analysis. Same thing with the weighted average cost of capital or something like that, or discount rates as well. As legal historians often try to tell complex stories about the effect of multiple factors such as time, race, and gender, those can all be included in regression analysis. And it is notable that neither of the authors of the 2 works that use regression analysis have PhDs in history. So even these complex quantitative tools, regression, is not actually used by those with PhDs in history, so they came from other fields as well. Michael Landis Dolber received her doctorate from sociology, and Paul Mahoney does not have a doctorate, though is well known for his works in law and economics. So they're still outside of what we would call legal historians or PhDs in history. This will be shown in section 3 as one of the reasons there is so little quantitative analysis in legal history is that the history graduate schools, which over the last few decades have trained the most prominent legal historians, do not generally teach quantitative methods and have relatively few faculty who use quantitative methods. And this is quite telling because he comes from the University of Chicago, which is a very quantitatively focused school, and he received his PhD in history. The next section will discuss Dolber's and Mahoney's books and Gavin Wright's Sharing the Prize in some detail as examples of the way statistical analysis can enhance works of legal history. So briefly, some examples of the benefits now that we've seen a little bit of the groundwork of where its place is in this field. So while relatively rare for legal historians to use quantitative techniques, there are 3 excellent examples that will be discussed here. So first, A, Gavin Wright's The Sharing the Prize, published in 2013. So this one provides a compelling illustration of the way relatively simple tables and graphs can be used to shed light on one of the central questions in modern legal history, whether the civil rights laws in the mid-1960s worked. The author focuses on the South, arguing that the Civil Rights Act in 1964 and the Voting Rights Act of 1965 have had the biggest impact on the region, and that it is best to analyze their effects on a regional basis. So that's his conclusion. And he found that civil rights legislation also affected the North, but Wright argues that previous studies provide a less clear picture of the success of the civil rights revolution. And he checks this quantitatively, and he says because African Americans started from a higher baseline in the North, so there's some sort of skewedness in these studies, which we will elaborate shortly, and therefore focusing on the South produced unambiguous economic gains without harming Southern whites, and that's one of the findings, and different political and economic dynamics existed in the two terms, but we'll see how this works quantitatively. So most often shows the effects of the civil rights legislation by using graphs and charts that compare some variables, for example, per capita income or department store sales over time. And they nearly always point to some positive improvement starting around 1965. So it seems, based on the data, that most economic indicators have improved since 1965, which might indicate that those 2 pieces of legislation had a positive impact shortly after the Civil Rights Act and the Voting Rights Act when compared to national trends, and showed that the whole country was doing but when compared to national trends, it showed that the whole country was in fact doing well in the 1960s, and the South was doing even better, and that this divergence from national trends started around 1965. But was it caused by something else, however? For example, black male median income rose in all regions between 1955 to 2000, but black male median income in the 1950s was less than half the black median income in the Northeast and Northwest and Midwest. By 2000, black median income in the South had risen so much that it was virtually identical to black male income in other regions. So it had a lower starting point but grew to be almost the same, so a larger magnitude increase. Similarly, Southern male incomes for both whites and blacks grew between 1955 and 2000, but black Southern incomes were less than half of white male incomes in the 1950s. By 2000, the gap narrowed dramatically, although it is still significant. There's still a gap between the incomes between white males and black males. He also looks at net migration as an indicator of economic change. From 1900 to 1960s, both white and black individuals were leaving the South. For African Americans, this exodus is often called the Great Migration. The net migration of whites was also occurred during the same period because there was still better economic opportunities in the North. While a small number absolutely and percentage-wise is evidence that segregation and the Jim Crow laws and discrimination did not really benefit the Southern white population, hence the moving north. And starting in the 1970s, migration patterns for African Americans reversed themselves, and hundreds of thousands migrated back to the South, or from the South for the first time if they were from the North originally. And the white patterns also shifted, however, albeit a decade later. So if the whites were also shifting too, then maybe they're having a positive, these changes, new legislation also having a positive impact for the whites as well if they're to return. But there was a delay as well. that economic and political gains to African Americans did not come at the expense of whites, but instead whites and blacks shared the prize. And hence that is the title of the chapter. They shared the prize, and it didn't just benefit one group. Health 2, he covers, for example, southern hospitals after desegregating almost completely in just a few months between July and December of 1966 to maintain, so a lot of them desegregated quickly in order to maintain Medicare funding, and improvements to health outcomes were dramatic. Black infant mortality in the South, which in 1950s and 1960s was roughly double black infant mortality in the North, converged to the northern rates by 1975, so almost completely caught up. Right? It did entirely catch up, with most dramatic drops in the late 1960s. Although white infant mortality both in the North and South also declined, and black infant mortality in the North did as well, and improvements among Southern African Americans were much larger, but it did not reflect just better access to quality hospitals, but other changes including improvements in education, nutrition, and sanitation, so there's underlying variables as well. But the desegregation of schools also increased black incomes and African American political power, and thus helped ensure that public investments in sanitation benefited Americans as well as whites, black African Americans as well as white Americans. This also addresses some of the downside of the civil rights revolution, for example, including negative effects on black business districts. So after there was desegregation, the districts they spread out and they no longer stayed local or stayed close. That also shows some persistence of poverty and the possibility that the political and ideological legacy of the civil rights era has served to impede further progress in recent decades. Also notes that litigation, local organizing, and individual courage were usually necessary to transform law on the books into change on the ground. So there was more than just creating these laws. It took courage, and it wasn't just by the lawmakers, but also by the individuals. Although Wright, Dolber, was aware and discussed the extensive econometric literature of the civil rights, the book eschews complex statistical analysis for easy to understand graphs and tables. So basically, a lot of looking at trend lines, like what was the improvement on a certain variable in the North and what was the improvement in the South, and to compare the effect of the legislations. But he does it in more simple terms, even though he's aware of econometric literature, and in this way serves as a model for many legal historians who neither know statistics nor have any inclination to learn it. So this is something that any legal historian, he believes, could grasp. Of course, the fact that Wright's graphs and tables are easy to understand does not mean that they were easy to create. In fact, like elegant narrative history, effective presentation of quantitative analysis takes many drafts, experimentations, alternative formats, and attention to reader feedback. So it's not easy, that being said, which hopefully might motivate some people to do it, because people wouldn't want to do it if it was too easy. So moving to the second example of 3 of the effective uses of the quantitative method in legal history. This is by Paul Mahoney, Wasting a Crisis, Why Security Regulation Fails, published in 2015. So the analysis of history, so he analyzes the history of securities regulation with heavy reliance on regression analysis, so one that Daniel Klerman Professor Klerman refers to as one of the more complex quantitative tools. In his view, prior historians have been bamboozled by the self-serving statements of legislators and regulators who have touted their work as serving public interests. In fact, Mahoney argues much of securities legislation has benefited special interests, such as small banks or established high-end brokerage houses, at the expense of consumers. To reach these conclusions, he uses tools of political economy to analyze the political coalitions that lobbied for legislation and the use of statistical tools of financial economics to explore the effects of regulation. And we can use many variables because we're using regression analysis here too. So he starts with analyzing what are called the Blue Sky Laws, which were state laws enacted between 1911 and 1931, ostensibly to prevent fraud in the securities market. Mahoney found that the states that enacted the most rigorous merit review statutes were not those that had a greater incidence of security frauds, but rather were states where small banks were common and and were common, and stockbrokers were scarce. So there seems to be a different, a stronger correlation between the amount of small banks and fewer brokerage houses than the actual amount of securities frauds. Small banks feared that potential depositors would invest in stocks rather than savings, so small banks sought regulation that would reduce securities offering. So perhaps there's a different political agenda going here behind the curtains. In states where the securities industry was already well established, and thus where there were many stockbrokers, the security industry could lobby effectively to prevent legislation, so these laws were not enacted in these areas. In states where securities industry was weak, such as Kansas, Arizona, and North Dakota, small banks were more effective politically and could get the stringent regulation they sought. In contrast, where small banks were weak and the financial industry was strong, such as New York, New Jersey, and Delaware, blue sky legislation was weaker. So, and I think you might be able to conclude securities fraud is higher in those areas, involving ex post litigation about fraud rather than pre-offering screening for merit or fraud. Even though securities fraud was undoubtedly a larger problem in New York than in North Dakota. Unfortunately, there is no good data on the incidences of securities fraud, because, well, if it's not tracked, we don't know, but so Mahoney cannot test whether blue sky's laws actually reduced fraud and thus benefited the consumer, but we can see that the cause might be that the number of small banks, or how strong or how many brokerage houses on the other side there are. And he uses regression analysis extensively, and he rightly does not use tables because so many factors could affect the adoption of stringent legislation, including the incidence of securities fraud and the strength of small banks. So by running a regression analysis, you can see what is causing having the largest effect, and it seems to be less correlated with the number of incidences of securities fraud, but more with the number of small banks, or the strength of the Democrat Party and the progressive politicians, and as well as the securities industry. When analyzing so many factors, tables become very cumbersome, and regression analysis is the most appropriate way to identify important factors. He later discusses other issues in the history of securities law. He says, perhaps most interestingly, the analysis of whether the Securities Exchange Act of 1934 actually improved public disclosure. The market failure narrative that Mahoney aims to debunk asserts that the public generally had very poor information about publicly traded securities before the 1934 Act, and that all the Act's mandatory disclosure provisions provided valuable information to market participants. Mahoney and his collaborator, Jianping Mei, test the theory using techniques from financial economics. If disclosure mandated the Act aided traders, the prices would more accurately reflect the traded value of the stock. And for example, when the firm announces earnings, there would be less of a big jump or drop because there's more disclosure and therefore better information sharing. And by comparing reactions to earnings announcements before and after the implementation of the Act's disclosure, one can assess whether mandatory disclosures improved information to market participants. And he finds that they did not in a sample of 201 companies listed on the New York Stock Exchange, nor was he surprised that security SEC's requirements were modeled on the requirements already imposed by the New York Stock Exchange. So the requirements already through the New York Stock Exchange were already sufficient to not cause any perceptible difference with this new act. While the SECs were somewhat different, the differences were not measurably large enough. So in terms of this book, he says this book should serve as a warning to legal historians who often rely heavily on what historical actors themselves said. So the two acts, they might say, oh, like this was done to prevent incidences of securities fraud, but evidently it might have been done because of the lobbying of the banks. On the other hand, in terms of public disclosure, oh, it would be better for the consumers, but is it really? It didn't really do much. So that's the conclusion here, and he argues that what legislators and regulators have stated often is wrong or misleading, and in these cases they made assertions that they thought were politically expedient, they thought they might be convincing to the public. Nevertheless, Mahoney argues that quantitative analysis of what the legislators and regulators actually did, and the effects of their actions provide superior insights into the policymakers' motivation and whether the policies actually benefit the public. So very fascinating findings and evidence of the benefits of quantitative legal history. Moving now to the third and final example, Michel Landis Dolber's The Sympathetic State, published in 2013. So Michel Landis Dolber takes a significantly different approach. In Chapter 7 of her book, The Sympathetic State, she uses quantitative analysis of letters to Eleanor Roosevelt to uncover the moral economy of public assistance. The letters usually asked Mrs. Roosevelt, so during this time a lot of people would send letters to Mrs. Roosevelt and she would act upon them and implement them in some cases, for material assistance, and provided a narrative the author hoped to convince the reader that he or she was deserving aid. So these letters were written trying to convince Mrs. Roosevelt that they needed aid. And like Mahoney, Dolber is skeptical of the veracity of what people wrote. By comparing the content of the letters to census information, shows that the letters were often misleading, omitting important information and sometimes asserting facts that are likely to be flatly wrong. Nevertheless, it's very informative to analyze the letters, as omissions and distortions reveal what the writers were actually trying to convince. And she skillfully discusses the letters as notes. It is impossible to reliably detect systematic variation in a set of 529 letters by simply reading them, so we have to resort to quantitative methods. With so many letters, statistical analysis is necessary. One finding was that the letters did not vary much by gender, region, or indica of social class, and it infers that the letter writers shared a common view of what counted as a valid excuse, or at least that what they thought Mr. Roosevelt would consider as such. This agreement is a signal of the underlying moral economy in which these writers expected the letters to be read. Nevertheless, there are some uniformities. The letters that requested assistance with unpaid debts tended to include more excuses, probably because debt raises questions about whether the debt represents a flaw in the debtor's moral character and a willingness to spend beyond their means. So you kind of understand the moral economy. There's a negative connotation around debt at this time, and perhaps even still today if we were to study a large group of letters. One of the strengths of Dolber's approach is that she embeds statistical analysis in a compelling narratives. She starts with chapter summaries and quotations from several specific letters to get the reader feeling the nature of the sources. And then quantitative analysis needs not be dry, she notes, or the author, Klerman, he notes. It need not displace the moral tradition narrative and analytic method used by legal historians. It can be used to supplement them, especially when historians are fortunate to possess large amounts of source material. 529 letters, you cannot make strong conclusions based solely on anecdote. You have to use statistical methods. In those statistical situations, statistical analysis can allay suspicions the historians is emphasizing underrepresented pieces of evidence to uncover patterns or vectors that would otherwise be invisible. So once you've gone to the quantitative methods, it's not, you can't make the argument that the historian is hiding something. So briefly, a little bit on some other works besides these three. These three examples discussed in this section represent just a small sampling of legal historical works that use quantitative methods. Other scholars have used statistical analysis to address a wide range of issues, including the causes and effects of the 19th century expansion of women's rights, the effect of colonial imposition of common or civil law legal systems, the economic effects of the Glorious Revolution, the dynamics of medieval litigation, and the nature of slave-captain contracts. Klerman chose the books by Gavin Wright, Paul Mahoney, and Michel Landis Dolber because they illustrate the variety of ways quantitative methods can be used. So they kind of an overview of the spectrum. One's like simple tables, complicated regression analysis, and sort of as a contrast to anecdote. And some emphasize the numbers so much and seem too abstract, so much from the context of the legal historians that they are likely to find them persuasive. These three show how statistics can be woven into a broader theoretical and narrative context to form a cohesive whole. And further readings, we can see Daniel Klerman's Economics of Legal History in the Oxford Handbook of Law and Economics, as well as Braun Harris, The Economics Encounters of Economic History and Legal History. Braun Harris is a previously covered intellectual. And in the Law and History Review, and Daniel Klerman's Statistical and Economic Approaches to Legal History, published by the University of Illinois Law Review. But there are countless others, but these three really kind of give an overview of the types that we might see and the benefits. So moving to the third and last section of his chapter, the future of quantitative legal history. So the problem, sophisticated quantitative analysis is likely to remain marginal, he hypothesizes, to legal history. One of the key reasons is that legal historians are increasingly receiving their training as PhD students in history departments, where the faculty seldom use or teach quantitative methods. Until the late 1970s, quantitative legal history analysis and scientific history more generally were important parts of historical studies. Statistics were important to many kinds of historians, including Marxists, cliometricians, historians using modern non-Marxist economic models of large data sets. That's what cliometricians are, and followers of the Annales school. Yet, in the late 1900s, past the 1970s, many elite historians turned away from social science and statistics towards more traditional narrative modes. One of the many reasons for the shift was a bitter debate over Fogel and Engelman's analysis of slavery in Time on the Cross, and the consequence of the increasing statistical sophistication among cliometricians and of historians' turn to narrative is that quantitative historians are more likely to be found in economics departments than in history departments, and quantitative history is more likely to be published in economic journals. So sometimes maybe it could be legal history, but it's kind of in the economic journal. For example, Gavin Wright is a member of the Stanford Economics Department. As a distinguished economic historian, Avner Grief is notable exceptions. Avner Grief is also a distinguished economic historian. So they're kind of put in the economics department because of their use of quantitative methods. Some notable exceptions, however, are Naomi Lamoureux, although she is also a member of the Yale Economics Department, and also the chair of Yale's History Department, where she has the opportunity to influence a large number of legal historians. So there are some crossovers, such as Naomi Lamoureux. He says, economic history is increasingly published in economic journals. Similar trends can be found in legal history. Almost no sophisticated quantitative, however, they include almost no sophisticated quantitative analysis. In contrast, economic and statistical analysis of legal history flourishes in journals devoted to law and economics and political science. So when it starts combining with other fields, law and history, such as economics, law and economics, and political science, it starts to bring in more quantitative methods. Doctoral students in history can take courses in other departments to learn statistics and gain exposure to other departments that use quantitative methods for historical purposes. Similarly, those pursuing doctorates in other fields can choose to focus on legal history topics. Nonetheless, as long as quantitative works, he says, remain so marginal to history departments, it is likely to be understood in legal history as well. Some reason to be optimistic, however, that quantitative work may become more central to the field of history. Jean de Vries has predicted a return from the return to the narrative in the Law and History Review 831. If historians turn to social sciences, they will almost certainly use more statistics because they are an integral part of most other social science research. Relatedly, recent upsurge in work in the study of the history of capitalism may presage greater interest in economic history and in quantitative work. So that's another trend. History of capitalism might be causing more quantitative tools. On the other hand, much of this work eschews statistical analysis in favor of intellectual history or other approaches. The emergence of digital humanities may also revive interest in quantitative approaches, particularly the automated analysis of texts. It provides opportunities. The fact that the Law and History Review recently devoted a special issue to the digital legal history, and this handbook itself includes a chapter, which is this chapter, legal history, or a separate chapter, legal history and digital humanities, is encouraging in this regard. But also the fact it includes this chapter is encouraging in this regard. But computers are still more primitive, however, he notes, than expertise of the researcher. So it's not like we're going to have computers all of a sudden accomplish this for us. Legal historians might also be influenced by subfields of political sciences, such as American political development, where quantitative analysis is common, or as Philip Hoffman pointed out in the Journal of Historical Society, historians, including legal historians, could usefully employ tools from cognitive psychology and game theory, which are already revolutionary fields such as law and political science, because they're usually tested with statistical analysis of data, and this will inevitably lead to increased quantification. The Supreme Court database has recently updated to include the information on Supreme Court cases and justices all the way back to 1971, which can be used quantitatively, and so much of the relevant data has already been coded. To focus on other courts would require historians to code this data themselves, so there's kind of a blind spot. We're missing the lower courts. The Supreme Court database, however, may serve as a model, so that's not to say these will not, new databases for the lower courts will not be created. He also notes it is possible legal historians will be inspired by this chapter and other works to learn and apply more quantitative techniques. Hopefully you, by listening to this, will follow in suit by taking statistics and research methods courses offered by political science, economics, sociology, and other departments. And it's a useful resource for autodidacts, so people who can learn on their own. He suggests Lee Epstein and Andrew D. Martin's An Introduction to Empirical Legal Research, specifically intended for legal scholars with minimum quantitative training. It addresses the basics of statistical analysis and addresses important topics that statistics texts often ignore, such as research design, collecting and coding data, and persuasive presentation of results. So really all the foundation, all the way bottom up. And once again, it's titled An Introduction to Empirical Legal Research by Andrew D. Martin and Lee Epstein. Those who teach themselves quantitative methods would be well advised to share these ideas with drafts with social scientists in other departments. So even if you are an autodidact, he suggests collaborating. These conversations may help one avoid mistakes as well as spark more general conversations and interchange on methods as well as substance. Perhaps the most promising avenue for quantitative legal history would be collaboration between legal historians and quantitative social scientists. Co-authorship, he notes, is extremely common in social sciences, yet rare in legal history. So part of this is maybe even collaborations themselves are less common in legal history. And he finds this is strange, as collaboration provides a way to incorporate methods without requiring independent mastery by the legal historian. So if they collaborate, they don't need to be a master of that which they're collaborating with, and legal historians may more likely to learn considerably. Similarly, the legal historian can ensure that the quantitative analysis takes proper account of the historical context and that narrative and other techniques are effectively used in this exposition, so they can also check this quantitative individual. So, and lastly, the conclusion, he says, although few legal historians currently use quantitative techniques, those who do show the potential power to disentangle the influence of multiple factors, to reveal the effect of legal change, and to uncover patterns in large legal texts. That's some of the benefits of quantitative legal history. The recent interest of historians in digital humanities and the history of capitalism may foreshadow increasing use of quantitative methods by historians, which may in turn influence the next generation of legal historians. So it could be on the upward trend based on those trends. Or current legal historians could benefit by educating themselves in quantitative methods or by collaborating with empiricists from other schools and departments. So overall, this chapter is very much a call for the readers or the listeners here to learn their statistical methods, either the autodidact approach by studying it themselves, but even if they choose to do that, to collaborate as well. So that is the chapter, Quantitative Legal History by Daniel Klerman, number 19 in the Oxford Handbook of Legal History, in section 2, Approaches, Conceptualizing Legal History. As for the content I have here on the slide, the institution he works at is the University of Southern California Gould School of Law. His position is the Edward G. Lewis Chair in Law and History, and he is also the director of the Center of Law and Social Science, also abbreviated as CLASS. His research interests are civil procedure, English legal history, law and economics, property, concepts in American law. In terms of suggested readings, we have Articles The Law Matters Less Than We Thought with Spencer Holger Spauman, published in the 40th Journal of Law and Economics Organization. It's forthcoming in 2024, so I'll have to wait a little time to read this. And next article, The Transformation of the Art Market, Law, Norms, and Institutions, published with Anja Shortland, into the 23rd Theoretical Inquiries of Law, pages 219 to 41, published in 2022, this year. In terms of the logos, in the top left, we have the USC Gould School of Law, where he currently works. Top right, we have the University of Chicago, where he received his PhD and law degree. Below that, we have Yale College, where he received his bachelor degree in history. Let's double check that's correct. Yes, history, mathematics, and philosophy. Pardon me, don't get it right. Wrong. In terms of the quotes, we have quantitative legal history is in a rather sorry state. Only about a quarter of recent works of legal history use even simple quantitative methods such as tables or graphs, and articles or books with more sophisticated methods such as regression analysis are extremely rare. Sophisticated quantitative analysis, next quote, sophisticated quantitative analysis is likely to remain marginal to legal history. A key reason is that legal historians are increasingly receiving their training as PhD students in history departments where the faculty seldom use or teach quantitative methods, so it's kind of self-reinforcing. And final quote, the recent interest of historians in digital humanities and the history of capitalism may foreshadow increasing use of quantitative methods by historians, which may in turn influence the next generation of legal historians. Or current legal historians could benefit by educating themselves in quantitative methods or by collaborating with empiricists from other school departments. So that is the chapter by Daniel Klerman, Quantitative Legal History. We'll now move to the chapter by John V. Orth, titled Blackstone. So now we've moved into part 3 of the textbook, titled Perspectives, Legal History in Modern Legal Thought, and this is specifically focused on Blackstone, which I quite like because I really enjoy taking the human approach as well. So in terms of his introduction, actually a little bit about his biography. He is the William Rand Kennan Jr. Professor of Law Emeritus at the University of North Carolina at Chapel Hill School of Law. He received his Juris Doctor and PhD at Harvard in 1974 and 1977, respectively, and he received his Master's of Arts in 1975, and he graduated from Oberlin College with his bachelor's degree in 1969. He was a clerk for Judge Gibbons of the U.S. Court of Appeals, Second Circuit, which covers parts of Delaware, New Jersey, and parts of Pennsylvania. His areas of expertise include legal history, property law and real estate, trusts and estates. And I think we can also say legal history and Blackstone himself. He's been part of North Carolina's law faculty since 1978, an author of 6 books, 3 of which are published by the Oxford University Press, which published the Oxford Handbook of Legal History, as well as over 90 articles and book chapters. They cover topics including labor law, constitutional law, both federal and state, legal history, wills and trusts, and basic property rights. Some of the books include Due Process of Law, A Brief History, with a Y. Mincheng translation, published by the Commercial Press of Beijing in 2006. Next book, How Many Judges Does It Take to Make a Supreme Court? And Other Essays on the Law and the Constitution, published by the University of Kansas in 2006. Due Process of the Law, A Brief History, published by the University of Kansas in 2003. And the North Carolina State Constitution with History and Commentary, published by the University of North Carolina Press in 1995. His works have been cited by federal and state courts, including the United States Supreme Court and the North Carolina Supreme Court, and he also has extensive contacts with Australian law professors and several articles comparing American-Australian law, so large Australian influence as well. So, moving to his chapter on Blackstone. So in terms of the introduction, Sir William Blackstone, living between 1723 to 1780, so only 57 years old, important to note, or 57 years he covered. is the author of the single, he says, is the author of the single most important work in the history of common law. It's a very important book, which is the 4-volume Commentaries of the Law on the Law of England, published from 1765 to 1769. And it culminates a series of lectures he delivered at Oxford starting from 1753, and it changed the way lawyers thought about law. Unlike all leading figures, he made contribution not as a judge or as a legislator, but as a scholar. Copies of the commentaries spread rapidly throughout England's colonies, where they proved to be even more influential than in England itself, particularly in the United States. Nowhere more so than in the ex-colonies that became the United States. So, first section, titled Biography. So, Blackstone's biography, he says, hardly prepares. So this is a biography of Blackstone. Blackstone's biography hardly prepares one for the scale of his scholarly achievement, he says. The details of his life, devotion to university service and law are undocumented in Wilfred Prest's 2008 biography. And he says, despite Blackstone's difficult personality, his undoubted mastery of common law demonstrated by his lecture series and subsequent book eventually earned him a university professorship and a steady stream of legal clients. Later a seat of parliament, this is Blackstone from 1761 to 1770, and a knighthood and judicial preferment from 1970 to 1780. He had many talents and a wide range interests, including architecture, poetry, Shakespeare criticism, prison reform, and which alone he would deserve a place in the gallery of 18th century worthies. But without commentaries, he would have been distinctly minor. So basically, his commentaries is by far his most important work, but he's still a very worldly polymath. Prest's research, the biography that Prest wrote about him, is so exhaustive that seemingly little remains to be discovered about Blackstone's life, so he does still appreciate Prest's biography. Although Prest recommends further investigation into Blackstone's lectures, the regional and social characteristics of his clients, and his European contacts and correspondence. So, but he largely relies on Prest's biography of Blackstone as the authority. So, in terms of Blackstone's time as a law professor, as with many other great books, commentaries began as university lectures, and it's proof positive, if any were needed, of the intimate connections between teaching and scholarship, as at least for me, by presenting these, I'll learn much more just by reading it, speaking it out is the best way for me, and trying to formulate the ideas in a packaged form. From their inception, his lectures displayed a paradoxical aspect. It was a conservative project with radical implications. Before the lectures, the only taught law at English universities was civil law, so they didn't teach common law at universities before Blackstone. Based on the system of jurisprudence of the Corpus Juris Civilis, which was published between 529 to 534 by order of Justinian I, so you can see in one of my previous videos, Justinian I was a Byzantine Roman Empire, and he drew a lot of these ideas from Corpus Juris Civilis from Caius, but this formed Roman law, which influenced France, which influenced Germany, which influenced the whole common law world, or pretty much anything that isn't common law. It was organized, rational, and written in the learned language, so it was also in Latin. Roman law was endowed with prestige of classical civilization, so it was Roman, it must be good, and it was the only one that was taught, for example, Oxford at the time. Common law, by contrast, appeared uncouth and almost barbaric. Its basic vocabulary of medieval Latin and degenerate French, tainted with feudalism and the compromises of practice and the marketplace. Foreshadowing Paul Cézanne's later ambition to make Impressionism like the art of the museums, Blackstone sought to make common law fit for the universities, which, as we see, he did. He began by offering lectures as a private venture, open to fee-paying students, so he would kind of teach common law on the side, a precocious example of the marketplace ideas, so people were willing to pay for it, evidently it must be of value, when a generous bequest by Charles Vinet permitted the establishment of the Venerean Professorship of Common Law. So the first professorship at Oxford was called the Venerean Professorship of Common Law, and Blackstone became the first incumbent of 1758. They still continue to offer but even after he became a private professor, he still continued to offer his private course until 1966, so 8 years later. Thereafter, his book made the lectures available to readers far beyond the confines of Oxford, so he still taught on the side, but once he published this book, it really expanded throughout the entire empire. No one can understand commentaries without first understanding the lectures from which they sprang. In advertising a course, Blackstone announced that he proposed to lay down a general and comprehensive plan of the laws of England, to deduce their history, to enforce and illustrate their leading rules and fundamental principles, and to compare them with the laws of nature and other nations, to cover the entire law school curriculum, including legal history, jurisprudence, and common law, comparative law. So very, very ambitious field, as we've seen in previous chapters. Comparative law is almost hardly even exists today, but even at the first professor endeavored to do this. It was not intended for lawyers, even particularly law students, but undergraduates who were desirous to be in some degree acquainted with Constitution and the plithy of their own country. So it was for a generalist approach for everyone. And he announced that he would avoid the practical niceties or the minute distractions of particular cases, the characteristic concerns of practicing lawyers. So lawyers were really focused on details, precedent, but Blackstone wanted an all-encompassing sort of idea for students of all majors. He prepared handouts additionally to aid students in the course, first as sample broadsheets and later as a 200-page outline. So the syllabus is like the length of some books. And the syllabus was titled An Analysis of the Laws of England, and it was first published in 1756. And so useful was this analysis as an introduction to English law that it was soon in demand outside the university, even outside the common law world. So the syllabus essentially is getting popular in the entire empire, or outside of England at least. Over dozens of years, he offered the course, periodically produced new editions of analysis until it was superseded by commentaries. So this syllabus expanded, starting from 200, or got into 200 pages, and then expanded into commentaries. And the basic structure and contents derived from the former. Like all lecture courses, it evolved over the years. Student notes, several sets which have survived, can be observed, allow for a reconstruction of the steady refinement of details of his general comprehensive plan. An example of what such sources can reveal is shown by press comparison of student notes from successive series of lectures, where you can document a growing significance that Blackstone accorded the Magna Carta as he prepared scholarly editions of the Great Charter for publication in 1759. So a growing popularity of Magna Carta. As we've seen previously, the Magna Carta was not as big or popularly used at its inception. It actually grew over time. Revised editions of the Great Charter, along with essays on collateral consanguinity, which is of the same blood, copy holders, and the law of inheritance was published in 2 volumes in 1762 on the title Law Tracts, so it expanded to include many different topics as well. Blackstone's lectures and ensuing book made English law available to a wider audience, but the mere fact that the lectures initiated a reorientation of legal training with momentous consequences. So it's no longer really a profession just taught by doing, but taught in a course. Learning from law lectures rather than from unsupervised reading and observation of working lawyers and judges. Previously, the only means of legal education was through that student, so it was very much more of a profession than as an academic topic. And this led to a slow divorce of legal study from legal practice. So there's some people, for example, that have stayed in the academic community and have never practiced even, as we see today. Thereafter, common law was increasingly expressed as an organized statement of rules with steady growing role for the law professor. So he was the first law professor, and now we have countless law professors, who together with the judge and legislator came to form the trinity that made modern common law. So professor is as equally as important as the judge and the legislator. So moving to commentaries, the actual book itself. Although commentaries deserve the greatest scholarly attention, they also pose the greatest difficulty for researchers, he says. John B. Orth says. Consistent with Blackstone's project to present the common law as intellectually respectable, his creative restatement of the law gave it coherence it previously lacked. So he created something out of nothing. Nor was Blackstone's plan of the laws of England quite so comprehensive as he claimed. But before examining these issues, it is necessary to examine the text itself, which we'll see. So, in terms of the text of commentary, so I really like John B. Orth's style of this essay. He kind of starts broad and just digs in. Now, talking specifically the text of the commentaries. So, in the last few decades, a split has developed among scholars concerning which edition of commentaries to study. In 1979, the University of Chicago Press published a facsimile of the first edition of 1765 to 1769, and this has become popular with Blackstone scholars, so a lot refer to the oldest version. Particularly historians focus on this. Just as the lectures evolved over the 12 iterations, so the published text evolved over 8 editions published over Blackstone's lifetime. Posthumous editions were advertised as well, including the last correction of the authors. So even after his death, or beyond the 8 that were published within his lifetime, there are others that followed as well. And it also began to include editors' notes devoted to later developments, beginning in the 12th edition in 1793, and he died 13 years previously in 1780. Prepared by Edward Christian, the text of commentaries achieved the status as a classic with standardized pagination indicated on the margin or inserted in the text. All subsequent editions indicated the standard pagination with an asterisk. The Star edition it is referred to. When the Star page is cited, legal editorial practice dictates the omission of the date and the edition unless the citation to the material added by a particular editor. So countless iterations, but basically they still reference back to the last one before the Star edition, or the last one before his death. The first volume of Chicago Blackstone, the Chicago Blackstone, which refers to the oldest one, is a facsimile of the edition published in 1765, which Blackstone corrected for a new edition in the volume following the following year, so volume 2. Later, lawyers and judges have often been influenced as much by his posthumous notes as much as by the text, so some actually rely very heavily on the notes that were never even published within his own lifetime. Information on many American editors is provided by Michael Hoflick's American Blackstones, so there's even books written about the variety of Blackstone's texts. In Press, Blackstone and his commentaries, edited by Press notes that the absence of local Australian and New Zealand editions has caused Australasian lawyers to import English, Irish, and even American editions. So it's kind of spread out and been adopted in different countries, and then since Australia and New Zealand, as John B. Orth is actually an expert on Australia, they haven't created their own Blackstone, so they're drawing from American Blackstone, for example, or English Blackstone. In 2016, the Oxford University Press published a adverarium edition allowing study of Blackstone's developing thoughts as well as his response to political pressure to which he's exposed, so the underlying trends as well, the political trends below. Shortly after the publication of Volume 1 in 1765, for example, the adoption of the Stamp Act precipitated a confrontation with the American colonies. By then, Blackstone was a member of Parliament and a loyal supporter of Tory causes, and he hastened, first in the supplement and then in the later editions of Volume 1, to significant qualifications of his earlier statements concerning the applicability of common law in the colonies to emphasize colonial subordination to the imperial crown and the Parliament of Great Britain. So there's political pressures that maybe that's a reason why one might prefer the Chicago edition, go with the original one before, affected by his time as a parliamentarian. Most notorious example of Blackstone's revisions involves the seemingly technical question of the eligibility for election to Parliament, which unexpectedly became a major political issue in the case involving John Wilkes, not John Wilkes Booth, the man who shot Abraham Lincoln, John Wilkes, who came much previously, who was speaking in the House of Commons in 1769 in support of the government's refusal. So Blackstone spoke in the House of Commons in 1969, supporting the government's refusal to recognize Wilkes' re-election after his expulsion. So John Wilkes was expelled from the House of Commons, and therefore Blackstone argued that he should not be able to apply for re-election. But Blackstone was confronted when his book was quoted against him, as he argued that expulsion disqualified a candidate for re-election. So his own book contrasted him, while Wilkes' supporters exulted with the biblical figure of Job. So that mine adversary has written a book. So one basically testifies against themselves in a book. Blackstone got the author's revenge by amending the later editions of commentaries, beginning with the fourth in 1770. So it's his book, so he revised it to address this, so it couldn't be used against him. Blackstone was not in favor of John Wilkes running for re-election. The book was revised, and essentially follows the biblical figure of Job, that my adversary had written a book. Property law content was not included until the 9th edition, posthumously, of 1783, 3 years after his death, prepared by Richard Byrne using autograph corrections on the 9th edition, so loosely connecting it to Blackstone, but it isn't real Blackstone. But we need to have property law. Perhaps Blackstone remained uncertain until his death how to accommodate the estate of two owners, so he's John B. Orth says he's very critical in that sense, that he wouldn't put something that he wasn't sure of, while largely but not completely functioned as a sole estate that was controlled by the husband, so he calls him logical Blackstone. So but that's evidence that maybe all the more reason to read Blackstone, because if he didn't try addressing things he doesn't understand, then that which he did address, he does believe he understands. Today, Chicago Blackstone remains useful study of his first thoughts, while the Oxford Blackstone allows study of his second and subsequent thoughts, printing all revisions to the first editions of each novel as well as some cryptic citations. For historians interested in the evolution of thought, Oxford Blackstone is invaluable, but for those interested in commentary's impact on the later developments of common law, the Starr edition, the one cited by lawyers and judges for more than 2 centuries, remains essential as well. It must be acknowledged how difficult it is to correlate the Starr edition with the Oxford Blackstone, and one must first know that the Starr edition incorporates a revision, not something normally indicated. In addition, one must know that which page the first edition of each volume the revision was inserted. For example, the revision made in response to the Stamp Act appear on page star 109 in the Starr edition of volume 1 was inserted in the first edition of volume 1 on page 105. So these are very technical, but it's clear that John B. Orth has really studied Blackstone's texts. In the Oxford Blackstone appears among the varia on page 327 of volume 1, and some deviations for revisions in response to Wilkes' controversy. So lots of deviations across the text, but which is the right one? Well, it depends on your purpose, but if you're an expert like John B. Orth, it's best to probably read them all. Next section is titled Sits in B, which is a term that means roughly translates to setting in life, which is a biblical criticism, where it stands for the context in which a text or object has been created, so setting in life, the setting around an object, and its function and purpose at the time. So sits in leaven, setting in life is the next section. So notorious, he says, that commentaries pay scant attention to contract or offer little of what today would be recognized as the law of tort. So not much on contract or tort law. But in this regard, they are largely reflective of existing law. The first book on the general principles of English law did not appear until a decade after Blackstone's death, and the first treatise of modern law, tort law, until the next century by John Joseph Powell, Essay upon the Law of Contracts and Agreements, published in 1790, and Francis Hilliard, The Law of Torts, 2 volumes, published in 1859. Even as a statement of the law on the 3rd quarter of the 18th century, commentaries must be treated with caution, for the book's structure has been set by the lecture course from 1753 to 1766, and 4 volumes reminiscent of the Institutes of Corpus Juris. So he kind of followed the civil law tradition, but it's important to know the context in which he wrote this book. So there wasn't much contract law, there wasn't much tort law, and furthermore, the only reference was Corpus Juris, developed from the lectures over 4 terms, and also that had to fit with the 4 terms of the Oxford academic year, and devoted, therefore, he chose 4 topics: rights of persons, rights of things, private wrongs, and public wrongs. and displays a pleasing symmetry of Palladian architecture. Blackstone could not have anticipated the dramatic developments of commercial law that were wrought by Lord Mansfield, Chief Justice of the King's Bench, in the 3 decades after 1756, so leading to beyond his death. To incorporate what would have required a radical redesign of commentaries, as demonstrated when Chancellor James Kent composed his 4-volume Commentaries on American Law between 1826 and 1830, where he omitted Blackstone's criminal law section, or his public law section, entirely and awkwardly runs the greatly expanded coverage of contract and related commercial law topics over volumes 2 and 3. So it's important what sits in living, setting in life. So the context in which this book was written, it might not be perfect for today, but it was best with available information at the time. Commentaries also hardly anticipates the significant role played by equity in contemporary legal practice too. One may be misled by Blackstone's confusion of the law administered by the courts of equity. So the courts of equity are not necessarily the chancery, they're called, with the generalized meaning of equity and fairness of individual cases, so there's not much concern for this. And this may be attributed to Blackstone's unease with discretionary justice, because he was convinced that, this quote by him, law without equity, though hard and disagreeable, is more desirable for public good than equity without law, which would make every judge a legislator and introduce most infinite confusions, as there would be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. So a little of a not only does he not seem too particularly favorable of equity, he also sees some negative consequences of it. And this is reminiscent of John Selden's classic quip that the measure of justice should not, like the length of the chancellor's foot, vary from judge to judge. By far the most important omission from the text, and the one with the most far-reaching consequences, is the absence of the extended discussion of the writ system. Then, at the time, was the nuts and bolts of English law. Before commentaries, legal literature was necessarily concerned with the intricacies of choosing the right cause of action. Substantive law was almost inseparable from procedure, but except for a few chapters in Blackstone, they essentially ignored writs, so there was not too much application, it seemed, thereby exposing legal rules to critical examination for the first time, so they could just be analyzed critically, not necessarily on the actions as well. Ironically, when on the bench, Blackstone showed himself more committed to maintaining the ancient distinctions than his fellow judges, but as a lecturer and author spared his audience many of these practical niceties, they call them, thereby allowing lawyers and non-lawyers alike an unobstructed view of the law's substance. So, sacrifice a bit of practical application, but in his actual work, this is his academic work, his work too, but in his work as a lawyer, he actually very much focused on these practical niceties. Next section, concordance of discordant canons. The greatest contribution as a scholar is to provide a logical structure for discussion of English law. His predecessors, in an attempt, though largely unknown today except by experts, his predecessors are largely unknown. Common law, a product of centuries of decided case, and it lacked inherent order. Tennyson, John V. Orth says, was not far wrong, although a little out of date when he referred to the lawless science of law, that codeless myriad of precedent, or the wilderness of single instances. So it was very focused on the specific. Blackstone's supreme achievement, therefore, was to take the accumulated case law and synthesize it into coherent intellectual whole. A creative restatement of law almost necessarily made it appear far more consistent than it was, and it minimized legal contradictions and sought to rationalize even the strangest aspects of English law, so once again avoiding the practical niceties, mainly by appeals to history in elegant prose, and gained the admiration even of his critics. The greatest challenge for modern researchers is to uncover intellectual moves as organized in presentation, since he took pains to conceal them. So the challenge is he's covered up some things. For example, presenting his rules for the construction of statutes in Volume 1, Blackstone confronted Sir Edward Coke's dictum that acts contrary to reason are void, in effect to claim that common law can control statutes. a form of judicial review and contradiction to the supremacy of Parliament, and this was hard won through the English Civil War and the Glorious Revolution, and he was unwilling to reject the outright so high authority as Coke. Blackstone restated the rule as acts of Parliament that are impossible to be performed or of no validity. So therefore, he drained the substantive potential, so it's not that bad laws can be, or bad acts can be eliminated. He says acts of parliaments that are impossible to be performed are not valid, so it's only under condition that they can be removed. In Aesop, Coke added, if there arise out of them collaterally any absurd consequences manifestly contradictory to common reason, they are with regard to these collateral consequences void and drained of any significant meaning. So even further, expanding it in that sense. There are a concession to the changing sensibilities concerning marriage. He, for example, emphasized the legal fiction of unity of persons and downplayed older justifications of legal disabilities of married women based on scripture and superior qualities of men. So he's kind of a modernist in terms of women's rights, kind of like a John Stuart Mill. This fictional unity of husband and wife later hardened into legal fact, the long-delayed recognition of the independent legal personality of women. So quite forward-thinking on women, it seems, according to John B. Orth, but it's still to be fully explored by scholars as an understanding of the relationship between law and economics, because this was written before Adam Smith's Wealth of Nations in 1776, so written 4 years before his death, and probably only dimly understood the connections of law and economics, although gaining recognition slowly in the cases. So there were some recognition of economics, but even Adam Smith's Wealth of the Nations is considered one of the oldest of modern economics, was only in the very latter parts of his life. And it justified cases holding that in nuisance, for example, to set up a mill, a school, or a trade in a neighborhood of a rival ship with one another, for such emulation of the public are like to be gainers. So he's an advocator in this sense for competition, for example, mills, schools, and trade. So free market, competition, Wealth of Nations, alignment there, so quite forward-thinking there. And he also thought that in the case of profits lost by competition, emulation, but there's also the creative destruction celebrated by economists, and he brandly dismissed with the Latin quip, damnum abjus injuria, damage without injury, so competition, there's no damage, brings benefit. But he also recognized public utilities, such as ferries built too near each other could be a nuisance, and they could be, and they should share the fines if they're built too close together. For example, they might crash. And they are also legally bound always to repair and be in readiness for the ease of the king's subjects. So public utility, like maybe if we should collect tax revenues to pay for these ferries if it benefits all the king's subjects. Similarly, they should share the cost of the waters if they're both operating there as that another public good. Next section, everything as it should be Blackstone. So Bentham, who the next chapter will be on Bentham, it would have been cool if we could have compared Blackstone and Bentham next to each other, but this is the way the cards fell. Bentham's epithet encapsulating his contempt for Blackstone, so they really disliked each other, or Bentham disliked Blackstone, as the complacent apologist of the status quo achieved such currency that it is difficult to see that commentaries actually contain significant criticism of the law and serious proposals for its reforms. Despite the well-known suspicion of statutes, many complaints required legislative solutions. Albert Alschler cataloged some of these proposals, creating a system of recording wills and deeds, expanding the right to counsel, restricting the death penalty, abolishing the doctrine of the bloodline of a felon, is corrupted in reforming England's game laws, inheritance laws, and poor laws. And this was in Rediscovering Blackstone, published in 1996. The Master of Law of Property delved into intricacies of the process of borrowing an entail. Entailment, I think of it. To Kill a Mockingbird, the man that Atticus Finch helps is an entailment, and then they all go to get the kid brings it up. It's a very cute thing, but I had to learn what an entailment is. Essentially, the individual cannot sell the land to raise money. They have to they have to stay on their land, essentially. With the goal of speeding up the process and rendering it less subject to niceties, he offered a short list of possible reforms, noticeably one that had been pioneered in the American colonies, an early recognition of the ways influence could run from the periphery to the center of Britain. So it also brought back to the British Empire. But essentially here, Bentham criticized Blackstone for not having enough practical niceties, but as we see, there are some clear benefits, such as an entail, which actually took place in the United States before coming back to the United Kingdom, or England. Commentaries and later on the bench, he laid great success on procedural protections for the accused. He was uncomfortable with the growing use of summary convictions with one or two justices of the peace after non-jury trials. He wappishly noted the common law courts had at least thrown in one check upon them by making it necessary to summon the party accused before the condemned, but he believed that the accused needed more rights. John Langbaine, while criticizing for overestimating the safeguards against judicial abuse, said Blackstone on judging pressed Blackstone and his contemporaries, was an article in that Prest's work, applauded him for identifying and recommending reform of the two worst features of the trial procedure of his day, the testimonial disqualification of parties for interest, and the lack of pre-trial discovery for documents and certain forms of testimonial evidence. So lots of these were practical niceties that in large part he tried to avoid, but they were there and very important. Yet Blackstone was rarely strident. His critical comments were usually couched in terms of emollient as almost to evade attention. His commenting on offenses against God and religion, for example, he was compelled to include crime of witchcraft, on which our ancient books are full. So did he agree with witchcraft? We don't know, but he had to include it because that was popular at the time and he didn't want to get in too much trouble. In various passages both of the Old and New Testament there also exist too, and it was punishable in civil as well as in common law. And it seems to be the most eligible way to conclude with an ingenious writer of our own that in general there has been such a thing as witchcraft, so he was convinced that there was witchcraft, though one cannot give credit to any particular modern instance of it. So he had never seen witchcraft, but he just didn't want to start an argument, it seems, so he was a little bit easygoing in that sense, and pointedly excluded the Jacobean statute on the subject from his list of the law's improvements. So he did not support the Jacobean statutes, which were helped decrease witchcraft, which is essentially just anti-womenism. Unlike Bentham, Blackstone's chosen role was to praise common law, not to criticize it. So Bentham was critical of Blackstone. Even Blackstone was trying to avoid criticism at all times. He says, our lawyers tell us that the law is a perfection of reason, and that was what it is not. Reason is not law. It's too honest to recognize the difficulty with this Panglossian formula, so he qualified it not that the particular reason of every rule of law can be at a distance of time be always precisely assigned, but it is sufficient that there be nothing in the rule flatly contradictory to reason, and then the law will presume it be well-founded. So he doesn't say that it's automatically self-fulfilling, that a law is in alignment with reason, but it should be. Law is reasonable because it presumes its own reasonableness. The burden of proving the contrary is on the critic. So he does, to some extent, assume its reasonableness, so bring in the Bentham to criticize it. Legal history after Blackstone will be a story of the reversal of this presumption, and future defenders of the status quo will bear the burden of proof. So it's kind of somewhat shifted since Blackstone, and it has today. So kind of almost like, yeah. So the strange, I was going to say guilty until proven innocent versus innocent until proven guilty. Next section, the strange career of the commentary. So as important to uncover what went behind the scenes as Blackstone prepared the lectures that became his great book is just as or more important to explain the remarkable staying power of the book. As England entered the age of reform in the 1830s, parliamentary legislation rendered so much of the commentaries out of date that the editor's notes seemed hardly adequate. In 1841, Henry John Stephen produced his new 4-volume New Commentaries on the Laws of England, described partly founded on Blackstone, It was the same number of volumes, compressing the coverage of tort and crime to find room for the greatly expanded coverage of contracts, as mentioned, and it seemed to indicate that commentaries would go out of the way of legal texts that survived in name only for a few years after the death of the author, so it seemed like it might have been likely to be replaced, and periodically rewritten by editors to keep them topical, such as Burns' Justice of the Peace. But that actually has caused it to maintain itself, in fact. And it still came out in new editions almost a century later. Stevens' new commentaries even went through 20 subsequent editions down to 1950. So Conventional English Law History, following A.V. Dicey, gives Bentham and his disciples credit for many 19th century legal reforms, but Benthamism was much less influential in America. So Bentham might have been maybe even more successful in the United Kingdom, but less successful so in America, whereas Bentham really shined. Commentaries was usually uniquely put down the deep roots at the end of the colonial period, providing a convenient portable summary of common law in a book-poor society. So there weren't too many books in America at the time, and there was just one book that was almost all-encompassing. In an oft-quoted speech on the eve of the American Revolution, Edmund Burke reported that the Americans had bought nearly as many copies of commentaries as the English themselves. So, that's accounting for population differences as well. And despite Blackstone's opposition to independence, his insistence on the absolute rights of individuals proved invaluable in the ideological struggle that preceded the separation. So, kind of like Job, once again, his books kind of was used against him. Bentham scoffed rejection of natural rights and did not go down well with the revolutionary generation. So Bentham's scoffing of natural rights was not popular in America, causing him not to be as popular in America, United States, which claimed for themselves certain inalienable rights. Additionally, it's likely that many American apologists grounded their arguments on Blackstone's comments concerning the common law in the colonies that appeared in the first edition of Volume 1, which lacked qualifications added to later editions. Blackstone modestly described the commentaries as a rudimentary and it was addressed to students that almost certainly understated his ambition. So it ended up being much bigger than he had planned, and could have hardly anticipated that his book would have been treated as definitive, not surprisingly in Westminster, rich in legal resources, where it never was. In America, the absence of other sources and accessible style made it the final word. So the lack of competition in America made it successful in that region. And the book was literally in the hands of the delegates at the important Virginia ratifying convention. A familiar presence in arguments in the U.S. Supreme Court during the first decades in its existence before the displaced by indigenous authorities, that's indigenous Americans, not indigenous peoples, themselves often inspired by the commentaries. In the late 20th and early 21st centuries, after decades of relative neglect, they reappeared in the Supreme Court, and they were hailed as the preeminent authority on English law for the founding generation, despite being originally for lecturers to teenage undergraduates, many of whom not destined for legal careers. Today, citations to commentaries actually exceed those from the earlier period, and the revival can in some way be explained by search for the original understanding of the Constitution. So this idea that the Constitution is right, well then we must go back to Blackstone as well. By Jesse Allen, inquired whether recent rise could also be a part of the broader trend towards citing classical common law sources. Is the court becoming more academic in its analysis? Is a hypothetical question John B. Orth presents. And however valuable to Blackstone in Supreme Court, it also needs to study the influence in the several states. For example, after independence was won, the federal structure of the republic meant that, unlike England, there was no national legislature with authority to undertake wholesome legal reform, so each state was to develop its own law for itself, and state legislators generally deferred to the courts, where Blackstone was accepted as unquestioned authority. North Carolina, for example, and aspiring lawyers reported reading Blackstone over and over again, especially Volume 2 on the law or property rights of things, and the Tree of Knowledge, later produced, designed as an assistant to students in the study of law, in which admirable system laid down by Blackstone in his commentaries is preserved. That's the title of the book, published in 1838. It's published by states to depict the division and subdivision of commentaries as branches of a large tree while making no reference to changes of the law since 1780s, either in England or America. So almost all these laws can be traced back to the last edition published during Blackstone's life. Beginning 1849 and continuing into the 1930s, North Carolina Supreme Court required that candidates for admission to practice demonstrate familiarity with Blackstone, and instruction in the state's law schools remains largely based on textbooks, heavily reliant on commentaries. In the early 20th century, State v. Watkins, published in 2012, reforming Chief Justice and judges, one of the dwindling number of states, that they rely on uncodified common law for definitions of major crimes such as burglary, robbery, and arson, so it's in the terminology, and North Carolina courts into the 21st century still quote Blackstone on elements of these crimes. So, next section, moving to after the commentaries. So Blackstone's career after the commentaries is something of an anticlimax. The consensus is that he was not a success at the bar, and his parliamentary career was not distinguished. Pressed, the biography suggests research into Blackstone's clients would enhance his reputation, and Emily Cadens demonstrated Blackstone's opinions of counsel repay further examination, but nothing can make him a leader to compare with those such as Thomas Erskine or William Garrow. Similarly, while press draws attention to Blackstone's parliamentary contributions as behind-the-scenes committeeman, nothing can alter the fact that his political impact was negligible. According to John Orth, his reticence to speak in debates was exceeded only by Edward Gibbon's total silence, so he did not speak much. It is unlikely that anything will alter Sir Louis Namier's magisterial judgment. Of the 14 speeches Blackstone did deliver in the House, most were on subjects of secondary importance, and while very learned and original, they showed a lack of political common sense. So not as effective in his practical career, it seems. Of Blackstone's later career, the most interesting is his judicial service. Law professors on the bench is rare, more so in England than in America. In his day, Justice Blackstone was sui generis, which is Latin for of its own type, or unique. Soon after being named to the Court of Common Pleas in 1770, he accommodated a fellow judge by transferring to the King's Bench, then dominated by the dynamic Lord Mansfield. Within months, he seized the opportunity of the vacancy to return to the Common Pleas as a relative backwater. So maybe not even that ambitious as well as a career as a barrister and as an MP, and well, that is ambitious, however, and his judicial service calmly dismissed as, however, as not distinguished. After comprehensive review of the cases, Harold Hanbury, one of Blackstone's successors as Venerean professor, succeeded the negative assessment while loyally tempering its harshness. He said, if there were few diamonds in his judicial necklace, at least there were no gewgaws, which is a word I had to look up, which is slowly thin, especially useless or worthless. So although he said there were a few diamonds, he said none were especially useless. And this is someone who later held the same position as him as Venerean professor of law at Oxford. The oft-cited observation of Sir William Scott, later Lord Stowell, said more new trials were granted in causes which came before him on circuit than were granted on the decisions of any other judge who sat on Westminster at the time. So he might have been getting a different variety of cases which caused his less effect, explaining that Blackstone was so extremely diffident in his opinion that he failed to argue for it vigorously with his fellow judges. For example, in Onslow v. Horne, a libel action in which Blackstone initially presided, the rule was that even the slightest variation between the defendant's statement and the plaintiff's evidence, for example, quoting that the date as 11 versus 11th with a th was a fatal variance, but then he silently joined the judgment in the full court to grant a new trial. So he's kind of obsessive about details, almost to the hindrance of his professional career. But that's probably what made him so successful in writing commentaries. He was notoriously difficult to determine a judge's personal opinions from his decisions on the bench, but a judicial philosophy often does appear. In Blackstone's case, his insistence on strict rules to limit judicial discretion, although collegiality was the norm and dissents were discouraged, Blackstone overcame his diffidence and refused to go along with a judgment that he thought blurred the distinction between actions and trespass on the case. often caused to start over. He had an eagle eye and insistence that the proper cause of action was case. So he really does not follow the status quo. He was really willing to start again from the beginning in order to get things right. By far, his most momentous judicial utterance came in Perrin v. Blake, a landmark property case concerning the notorious rule in the Shelley's case, made famous by Sir Edward Coke's report in the 16th century case Wolfe v. Shelley. The rule defies simple statement, but was clearly implicated in the will at issue. Lord Mansfield conceded that the device was within the letter of Shelley's case, nonetheless refused to apply the rule if it would defeat the testator's intention. Blackstone worried that allowing the testator's intention to prevail over a rule of law would mean that every man would make a law for himself, which is reminiscent of his fear of equity without law, and warned against vague discretionary law. So he went against this powerful great Lord Mansfield, who a previous author in this textbook had noted was probably the most important lawyer in England of all time, thus, according to this author. Closely related to Blackstone, the judge is Blackstone, the law reporter as well. So he also had a career as a law reporter. From the time of his call to the bar in 1746, he compiled notes of decided cases, and they increased in number and the extent after his appointment to the bench. There's no official reporting at the time, and judges and barristers supplemented their incomes by publishing reports their own names. I think of in David Copperfield, he wants to be a writer, so he's working as a legal assistant, and he's writing his own books on the side. Well, these lawyers make extra by being reporters and at the same time. And they're called nominative reports. Blackstone's reports in 2 volumes were published posthumously by James Clitheroe, his son-in-law and executor, to raise money for the estate as well. Hanbury says, it has been suggested that his reports are the least satisfactory part of his life's work. Some have defended on supposition that he intended to revise them before publication, so if he didn't put them out in the public, they're probably not meant to be read as authority. But Caden pointed out there's no evidence to support that, saying the text of Blackstone it is the text he intended for us to see. So either side, do we follow these or not? Well, I think they're worth reading regardless. And one is attempted to call that even Homer nods, which is a famous term that even Homer makes mistakes or sleeps as well. Reports were a competitive industry as well, it must be noted. For example, Lord Mansfield was well known for doubting the report. We must not always rely on the words of the reports, though under great names. For example, Mr. Justice Blackstone's reports are not very accurate, so Mansfield directly criticized Blackstone, so Blackstone seems to get a lot of criticism, but he was willing to go against Blackstone as well. John William Wallace, in the 19th century U.S. Supreme Court reporter, critically examined all nominative reports and charitably concluded the matter of Sir William Blackstone's accuracy is the less important, as most of the cases he reported in the King's Bench are reported in Borough, and most of the commonly pleased by Wilson, 2 of the very best English reporters. So he's not perhaps the best reporter, and there's also this competition aspect, like they're writing things to get paid for this. But Blackstone probably had his own income, so maybe he could write more honestly. But variation was necessary, otherwise there's no point writing a plea that's identical to someone else. And Onslow, Scott, and Perrin present many variations, and there's evidently much significance of reading these though. So, moving to the last section, why Blackstone matters. Blackstone's commentaries were read by more people, non-lawyers as well as lawyers, than any other English law book. Their influence is difficult to overstate and extends into the 21st century. Almost as momentous was his influence on legal education. His demonstration effect on the Oxford lectures was immediately obvious in America, where the world's second professorship devoted to common law was established in Virginia in 1779, so quickly mirrored in the United States as well. While the gradual transfer of legal education from the law office to the courts to the university, which Blackstone pioneered, had an enormous impact on legal development, as law professors contributed to the formation of generations of lawyers and themselves came to play a significant role in legal development. So a huge influence there. And today his emphasis on rigid rules, both in commentaries and in judicial decisions, can be dismissed as legalistic itself. Exalting the letter over the spirit of the law sometimes seems to defend the indefensible. The faith of and the faith in legal rules, at least if rigorously enforced to protect individuals from abuse of power, may often seem naive, but his warning about discretionary justice, which would lead delegitimate equitable resolutions by enlightened judges, may sound more persuasive when judges are perceived to be oppressed or politicized. His lucid description of England's chartered liberties contributed directly to the development of a constitutionalist and rights-based jurisprudence, not just in America but throughout the world, and his vision of law as grounded in the historical experience of a particular nation rather than in rationalist principles earned him condemnation not as scientific but his anthropological approach proved more effective in understanding the interaction of law and society than analytic jurisprudence. His humane vision, for example, belief that there is no man so indigent or wretched that he may demand a supply sufficient for all the necessities of life from the more opulent part of the community, was certainly more attractive than the philosophy of utilitarian Gradgrins, which is, to look up what that is, word it meant, it refers to Thomas Gradgrind, who was a school board superintendent in the pursuit of profitable enterprise in the 1854 book Hard Times by Charles Dickens, which I've read many Charles Dickens books, but not that one. Furthermore, who invested in the fearsome poorhouses and their modern successes, so kind of a little counter argument against utilitarian or even perhaps capitalists in that sense, and that no individual is so wretched that they don't deserve any help from the state, essentially. The uncritical tone of Blackstone's presentation, which attracted Bentham's derision, may have stabilized the legal tradition, so it was probably maybe necessary that there had to be this clash of Bentham criticizing Blackstone. But at the same time, his limpid, clear exposition of the law's fiction and artificiality opened it to inspection and criticism as never before, and in its own way contributed to the modernization of common law. So that is the chapter on Blackstone by John V. Orth. Move to the slide and then a comparison here. So this is in section 3, Perspectives, Legal History in Modern Legal Thought, chapter 20 of the textbook, Blackstone by John V. Orth. So institution, University of North Carolina, Chapel Hill School of Law. His position is the William Rand Kennan Jr. Professor of Law Emeritus. His research interests include legal history, property law, and real estate trusts and estates. In terms of suggested readings, we have Catching a Falling Star, published in the Blue Book, and Citing Blackstone's Commentaries, published in the 2020 University of Illinois Law Review Online, 125, published in 2020. His book, Balancing Justice Needs, Private Property in Constitutional Takings Provisions, a Comparative Assessment of India, Australia, and the United States, published in the 42nd Fordham International Law Journal, 999, published in 2019. And another book on constitutional emoluments, The Emoluments Clauses of the North Carolina Constitution, published in the 97 Carolina Law Review, 1727, published in 2019. Pardon me, that's not a book, it's an article written in the North Carolina Law Review. As per the logos, we have on the top left the University of North Carolina School of Law logo. Top right, we have where he is a professor, or professor emeritus now. Top right, we have Harvard University, where he received his PhD and his Master's of Arts and his law degree, his Juris Doctor. Below that, we have Oberlin College, where he received his undergraduate degree. So, moving to the comparison in the style of Plutarch's Lives, where we will hopefully learn a little bit more about these two individuals. So they're both have a Juris Doctor and a PhD. So that's quite a similarity, but one, Daniel Klerman's, is at the University of Chicago, which is very much known for being a technical school, hence his chapter being on quantitative legal history, whereas John V. Orth's Juris Doctor and PhD were at Harvard University, which is kind of more of a school of people. So we could say University of Chicago is a school of things, or and Harvard's a school of people, perhaps. In terms of their undergraduate degrees, Daniel Klerman studied at Yale University, which is a very elite and exclusive school, whereas John V. Orth received his Bachelor of Arts from Oberlin College, which is a smaller liberal arts college. It's in Ohio, so a little bit more removed as well. whereas New Haven's deep in New England and very close to many major cities. In terms of their positions, they're both a professor of law. However, Daniel Klerman is also a professor of law and history in his title, but and he's at the University of Southern Carolina, which is a newer law school, but a very high-ranked law school in California, in Los Angeles. And whereas John B. Orth is at the University of North Carolina, which is an older school, but also in the East as well, or even in the South. So very different institutions, both hot, but one is very much more liberal or left-leaning, and one is a little bit more conservative as far as academic institutions go. In terms of their output, their writing output, Daniel Klerman has written a lot of articles, but one textbook, but not actually that many books or no books, essentially. Whereas John B. Orth has written 6 books and countless articles, and so more prolific on that front. But Daniel Klerman, we must note, is much younger, whereas John B. Orth graduated with his PhD in 1977 and became part of the law faculty in 1978, whereas Daniel Klerman was still didn't even receive his bachelor's degree until 1988. So John B. Orth was a professor before, 10 years before Daniel Klerman graduated with his undergraduate degree from Yale. In terms of their chapters, they're very different subject matters. One is quantitative legal history, which is basically an approach that can apply to anything, whereas John B. Orth is specifically on Blackstone, which, although Blackstone might have implication in all aspects of law, you could apply quantitative legal history to Blackstone, but you might not be able to necessarily link Blackstone to everything, but maybe you can if you're as sophisticated in this area or on this individual as John B. Orth. And also, I guess another distinction is that these 2 chapters were also put in 2 different sections, whereas Daniel Klerman's was put in approaches, conceptualizing legal history, whereas John B. Orth's is one on perspectives, legal history in modern legal thought. So that is the comparison, and that are the lives, and that are the chapters, or those are the chapters of Daniel Klerman and John B. Orth, respectively, titled Quantitative Legal History and Blackstone. So thank you so much for watching, and I hope you continue to support it. Thank you so much.